as is Mr. Grunander. The jury is seated. The state may give its rebuttal argument.
Hey, as both Mr. Grunander and Mr. Spencer said, we've spent 4 weeks doing this, and we've heard a lot of information. A lot of information has been presented to you today already. I'd like to respond to a few of those things. I'm not going to take up a ton of time to respond to all of those, because ultimately what I say is not evidence, and what Mr. Spencer just told you is not evidence, and what Mr. Grunander said. These are our summaries of what we think the evidence shows. I'd like to have you turn to instruction number 23. This instruction tells us that when we are giving our closing arguments, what we say is not evidence. And I point that out because it's your job to decide what the evidence was, to recall what you heard, and to make a decision based on that. A lot of what Mr. Spencer has just told you are speculative conjectures about what he thinks the evidence shows, about what conclusions he believes are properly derived from what the witnesses have told you. That's not evidence. Okay, let's, if you'll turn again to instruction number 20. Okay. This probative inferences from circumstantial evidence must be more than speculation or conjecture. So when you are making your conclusions based on the evidence presented to you, your job is not to speculate about what it could mean, or maybe what it did mean, or maybe what it doesn't mean. Your job is to interpret that evidence in a way that is based on reasonable inferences, inferences that are drawn on reason, not speculation. So for example, Mr. Spencer's statement that obviously the MacNeills had voicemail because of the way that he reads the phone records. That's his speculation. There's absolutely no evidence that they had voicemail, other than what Alexis said is that she didn't believe they did at the time. Another example, Alexis is responsible for the contents of Dr. Fricke's report. That's complete speculation. The only evidence we have is that Martin was the one that talked to Dr. Fricke and gave her those contents. For example, the use of the term day 6. That's somehow supposedly Alexis's unique marker. Doctors use that all the time. Dr. Thompson used day 6. In all of his reports, when you go look at them, you'll see day 1, day 2, day 3, day 6. When he visits someone, he's talking about the number of days after the surgery. He uses the same terminology. Martin's a physician. Dr. Thompson's a physician. Alexis is in medical school. The use of day 6 is an example of a speculative inference. That must mean it's Alexis talking. The evidence is actually that Alexis said that Martin did most of the talking during that interview with Dr. Fricke. So you must, as you are evaluating this case, you must rely on your memory of the facts and the notes that you have to refresh that memory, and not necessarily on what Mr. Spencer has represented to you or even what I'm saying, although I am going to do my best to represent things accurately. I'd like to start off by talking about the medicine, and I'm not going to get into numbers and details in the way that we have already. I don't think that's necessary. You have the exhibits and you have the testimony. What I do want to remind you of is that the doctors, all the doctors involved, all the medical examiners involved, have told us that that their role in this case is limited. And so this is not a case that is going to be defined and decided by you based solely on medical evidence. It can't be. There are limitations in the science, period. I mean, we haven't solved all of the mysteries of the human body and the processes that occur after death. And so, for example, post-mortem redistribution. The testimony on that is that it's a phenomenon that's poorly understood. You can't do studies on people that kill the people so that you can see exactly what happens and how those drugs redistribute. On that point, the defense pointed out the numbers in the toxicology report, and it was well established by all the people who testified regarding that toxicology report, that those numbers are hard to interpret because of all the variables involved. But I just want to point out, when Mr. Spencer was talking to you about those numbers, he pointed out that Dr. Perper used a dilution level of 50%. He said that was unsupported, even though there's no basis in the evidence for saying that's unsupported. The only evidence is that Dr. Perper said that he read the levels of Michelle's blood as representing a 50% dilution. So Mr. Spencer acknowledged that he was assuming something that was at the high end, in his opinion, on Dr. Perper's report. What he didn't acknowledge is that the numbers he gave you for postmortem redistribution, 12,000%, 600%, or excuse me, 1,200%, 600%, those are the very highest possible ranges for the postmortem redistribution. That's what Dr. Dawson testified to. Postmortem redistribution is better interpreted as a range, where the averages are actually down a lot lower than the numbers that Mr. Spencer gave you. There are limitations on the evidence in Michelle's body. A dead body can only tell us so much about what was going on in the circumstances leading up to that death. It can't tell us about the defendant's motive. It can't tell us about his opportunities. It can't tell us about the defendant's know-how. It can't tell us about all of the suspicious events that surround Michelle's death. And then again, as I mentioned, there are limitations in the role of a medical examiner, period. They look at the body, they look at a few circumstances surrounding the death, and they try to determine what the manner and the cause of that death was. They are not determining guilt. It's kind of a silly exercise, but if you look around you right now in that box, you're not going to see Dr. Gray or Dr. Perper or Dr. Fricke. That's because they have not been called upon to decide this case. And the fact that they don't find homicide is not the end of the story, as defense counsel would have you believe. The fact that they don't find homicide is a limitation of their role, and it's a limitation of their science. It means nothing when it comes to deciding culpability. That is something that Dr. Gray freely acknowledged when he was testifying. His role is limited to interpreting the scientific evidence on the body and a few circumstances around the death in order to determine that manner and cause of death. He specifically stated his role is not to decide culpability or interpret motive or decide who's responsible for the death. That's your job. They make their judgment calls based on their interpretations. Both Dr. Gray and Dr. Perper acknowledged that there can be disagreement between two competent medical examiners. They can both look at the evidence and reasonably disagree. Dr. Fricke looked at the evidence and thought she saw myocarditis. Dr. Gray reevaluated that evidence and thought, well, there's actually drug toxicity here too. Dr. Perper looked at it and said, actually, I think the weight of the evidence goes to drowning. Dr. Gray acknowledged, well, you know, if someone said that defendant told him that I drugged Michelle up and I put her in the tub and I pushed her under and helped her out, would that be consistent with what you see on the body? And Dr. Gray freely acknowledged, yes, that's completely consistent with what I have in the body, in the information that I can get from Michelle's body. So medical examiners, sometimes they can determine the cause and manner of death, sometimes they can't. And in this case, they had a very difficult time doing that. And that's why we have an undetermined manner of death. But that's okay. They're not the ones who decide this case. And murder cases are decided all the time without a medical examiner coming in and telling us what to do. Their information for us is educational and instructive. And they came here to do that to you today. I'm going to have you turn to instruction number 33, if you would. And if you look at the elements of count one for murder, you will see that there's absolutely no requirement that a medical examiner tell you that this was homicide. That's because that's your decision. Certainly they can instruct us and help educate us, but no medical examiner has ever decided any murder case. It's the jurors who evaluate the evidence as the entire body of evidence and not just specific lab samples or specific toxicology reports or specific slides. If we limited ourselves down to that, there'd be a whole bunch of murders that we could not solve. Defense told you in their opening statement and also today using a nice Venn diagram that all the medical examiners agreed that heart arrhythmia was the cause or the mechanism of death here. But if you recall the evidence that did not support that claim, they're saying again today the heart is the culprit. We have no evidence at all of a heart arrhythmia in this case. Dr. Fricke said the myocarditis was mild, and she said it appears to be the cause of death. She didn't say anything about a heart arrhythmia because, as Dr. Gray said, that can't be detected unless you're hooked up to an EKG when it happens and you die. Dr. Gray further said arrhythmia can't be proven and it doesn't leave a footprint. So the idea that all these doctors agreed and that what happened here was a heart arrhythmia is speculation. There's no evidence supporting that. Dr. Gray in his report, he added drug toxicity, and that's a very important consideration that you need to take, that you need to weigh. He testified that he rarely changes autopsy reports, which means that there's got to be significant weight to the evidence that he's presented with to move him off of the original position and to make an amendment. This change here was based on the drugs. And he changed the manner of death from natural cause to undetermined cause. That's also very significant. The defense has highlighted that the ME did not find homicide here. By the same token, after reevaluating the autopsy report and the evidence, he moved off of natural cause. And we have a stipulation that it's not suicide. So that change from manner in the manner of death is tantamount to Dr. Gray saying, I no longer think this is a natural cause of death. Otherwise, why would I come off of that manner of death that's already been concluded? Dr. Cragen testified to you, and he said that Michelle showed no symptoms that would lead him to expect that she'd have a fatal cardiac event anytime in the near future. Her blood tests were benign. Her heart rhythm was totally normal. And he concluded she was at a very low risk for any type of heart problem that would lead to death. Dr. Welch testified that during his preoperative examination before the cosmetic surgery, he recommended that she wait on the cosmetic surgery, but he said there's nothing that would give me the expectation that she was about to die. In fact, he was surprised upon hearing that Michelle died. He said she was a healthy middle-aged woman and he could see no reason why she should die a couple weeks after evaluating her. Dr. Thompson, his testimony essentially supports Dr. Cragen's evaluation. During his preoperative examination for the cosmetic surgery, he thought she was healthy. He didn't see any signs of any traumatic illness or any type of health malady that would lead to a sudden death. You can look at her vital charts during the operation itself, where over and over again, the heartbeat is reported as normal, blood pressure normal, everything's fine. After the surgery, Michelle was recovering fine. Everything is expected. No hiccups, no bumps in the road whatsoever. Finally, Dr. Perper took us through the slide that Dr. Fricke used to find myocarditis, and he showed us there are no inflamed cells there. There's no myocarditis here. He said if myocarditis is there, the pathology must show it. We didn't see it. He also testified that arrhythmia can't be proven, so he agreed with Dr. Gray on that. His opinion was that Michelle drowned that the drugs played an essential role in that drowning. And this contradicts what Mr. Spencer told you. This is another example of how you have to rely on your own memory of the evidence. Mr. Spencer said that Dr. Perper concluded that he doubts the drugs would cause impairment. In fact, his opinion was that the drugs played a significant role in Michelle's death. Why did they play a significant role? Mr. Spencer talked about the lack of signs of any trauma in a drowning in which Mr. MacNeill would be involved. There's no flowers kicked off of the tile pedestal that was down here. There's no signs of trauma on her body. Interestingly, Mr. Spencer he acknowledged at first that the ME did not see any signs of trauma on her body, and that except for the incisions that Dr. Thompson had made in the cosmetic surgery. But then later he tried to apply that she would have fallen through some sort of accident, and the blood in the water would have come from some sort of trauma, even though there is no trauma on her body showing a fall. So why wouldn't there be signs of struggle or fighting? Why wouldn't there be skin under Michelle's fingernails as she fought for her life? Why wouldn't there be just a mess everywhere? Well, if you're sedated to the point of being groggy and impaired, or, as Dr. Dawson said, all the way up to comatose, you wouldn't need to fight someone to get them under the water. And that's exactly what happened here. Mr. Spencer reminded you that Dr. Dawson said that there was no smoking gun in this case. But you'll remember that right after that, in his interview with the investigators, that no smoking gun comment was a convenient little excerpt that the defense pulled out. Right after that, Dr. Dawson went on to continue and to say, but there are shell casings all over the ground. He was suspicious from the beginning about this toxicology report. Ladies and gentlemen, those shell casings are all around Martin MacNeill. He asked for the drugs. The only knowledge that we have, the only evidence that we have is that on the night of April the 4th to the 5th, he administered those drugs to Michelle in the first overdose. She was, for the rest of the week, she never took Ambien, she never took Valium, she never took Phenergan. She was tapering down. She was down anywhere from half a pill to maybe 2 pills a day. That's not just Alexis saying that. That's Dr. Thompson saying that as well. And yet the very first time that Michelle is alone with Martin MacNeill again, all 4 of those drugs back in her system, and she's dead in a tub. The lack of any sign of struggle surrounding this drowning is tightly interwoven with the toxicity of the drugs in her blood that Dr. Gray acknowledged, Dr. Perper acknowledged, Dr. Dawson acknowledged. Dr. Thompson told you that when he prescribed this drug, or this combination of drugs, he recognized that was a dangerous combination. And the only reason he did it was because the caretaker for Michelle was a physician. Mr. Spencer pointed out that all those drugs were prescribed for Michelle's hospital stay. But obviously, no competent nurse or physician is going to come in and dose her up with all of them at the same time. Furthermore, in the hospital, people are regularly administered drugs in greater amounts or higher concentrations than they would ever be expected to do at home on their own without professional care. Anesthesia is the perfect example of that. No one is allowed to buy anesthesia, even with a prescription, and give it to themselves at home, or to have someone in their family give it to them. The point is that at the hospital, it's a completely different environment, controlled, monitored, and well, the patients are cared for by professionals. Dr. Dawson's opinion, the 4 drugs that were in her body would have created a profound depression of the central nervous system. That's the obtundation that Mr. Spencer referred to and that he talked about. When asked to describe what that looks like, he said it would lead to suppressed breathing, slowed cognition, impaired motor skills, and the person who had those drugs in their body being from anywhere from groggy and impaired to possibly comatose. He evaluated based on what he knew about Michelle and found that she was a drug-naive patient. You remember that means someone who's not accustomed to taking heavy narcotics, especially not all together at once. And this cuts very strongly against the defense's argument that all these drugs were in therapeutic levels or they were somehow in low levels. If you take 4 CNS depressants, even in the prescribed dose, and you take them all together, it doesn't matter that those are therapeutic levels. Dr. Dawson made very clear they have a combined effect. They all work on different receptors in the brain, they all put the brakes on at once, and they slow you way down. That conforms very precisely with inmate number 2's statement that Martin made to him. Hey, Doc, I heard that you murdered your wife. Did you do that? They can't prove it because those drugs were prescribed. Finally, Dr. Gray, too, found drug toxicity as a part of her death. This is important. I'm not going to go through all of it, but it is an important reminder that the only evidence that we have is that this battery of drugs right here on April 5th, the early morning of April 5th, was administered to Michelle by Martin. And I want you to kind of envision in a timeline from Michelle's surgery to her death, when it comes to the drug consumption, it's a general decline over time in the amount of drugs that she's taking, with 2 very important significant spikes. The first one is the first night that she's home and the first time that Martin's alone with her out of the hospital. Boom, not 4 drugs, all 5 drugs in her system. She's rendered sedated and unable to respond at least until the early afternoon, right here at 2:45. Okay, all these other ointments and treatments, those are external. They can be applied whether she's awake and asking for it or not. She wasn't able to have a meaningful conversation until that night. So you know the effect that these drugs have on Michelle. Heavily sedated. Okay, then Alexis takes over, and for the rest of the week, it's Percocet only. No Ambien, no Phenergan, no Valium. Steady decline, tapering off. It's not just Alexis who says this, it's Dr. Thompson who says it as well. You'll see it in his notes. And then Alexis goes home. The younger daughters go to school. Ada's at kindergarten. The very first time Martin's alone with Michelle again, oh wow, all 4 drugs back in her system. This time she's dead in the tub. Okay, that's not just state cherry-picking evidence. That is extremely weighty evidence, especially when you combine it with everything that the inmates said, which, if they were making it up, well, we'll get to that. We'll get to that. Mr. Spencer implied that maybe this was Michelle's fault. Maybe she took the drugs. There's no evidence to say that she didn't. You'd have to accept a whole bunch of assumptions to conclude that. Michelle, who was sensitive to drugs, didn't like taking them. Never took the Ambien or the Valium or the Phenergan, except when the defendant was around. Whom Alexis said was down to only half a pill or so of Percocet in the days before her death. Whom Dr. Thompson said was down to 1 to 2 Percocet per day. Who went out to eat a steak dinner at Sizzler the night before on the 10th. Who was up and active and cheerful in the morning of the 11th. And then all of a sudden was dead with all 4 drugs in her body. It is not consistent with anything Michelle did in the weeks before her death to think that she would have just popped those 4 pills in and then hopped into the tub or fallen into the tub under her own powers. The only reasonable explanation from our evidence is that Martin sedated Michelle with those 4 drugs during that one window of time he had her to himself and drowned her. Testified that there's a whole bunch of water that came out of Michelle when they were working on her. When she got to the emergency department at the hospital, they had to drain her airway. And both times, a foamy, blood-tinged fluid came out with the water. Dr. Perper was very clear that that foam comes from these proteins that mix with the water in the blood, creating that foam. That's an indication that there's water in the lungs and that someone has drowned. He talked about the blood dilution of approximately 50%. And he said, 17 to 20% of that could be accounted for by the fluids that they pumped her full of while they were trying to save her life, or at least trying to revive her. Because according to the paramedics, as well as Dr. Van Wagner, they thought she was dead upon arrival, which cuts against the defense argument that somehow she had recently died. That statement that her blood was diluted by 50%, 20% of it would come from resuscitation. The other 30% would come from dilution resulting from inhalation of water. Dr. Perper said that is uncontroverted in the evidence. Mr. Spencer getting up now and pointing out lab numbers, first of all, that's not in evidence. That's not even evidence. Second of all, he's not an expert, and he's positioning his own opinion of what those numbers mean against Dr. Perper's. Dr. Perper, who has published more than 100 times in every major journal in his field, who has been doing this work for decades, who is nationally regarded as at the top of the game in this type of work. It's not reasonable to accept Mr. Spencer's interpretation over Dr. Perper's, and it's not evidence either. Furthermore, Dr. Perper talked about hemolysis, when the blood cells burst and release their contents after death. He says that happens at a general rate after someone dies. But if there's water injected in the blood because someone drowned, the water makes those blood cells burst a lot faster. He saw that here. He saw the rapid hemolysis that indicates drowning. Heavy lungs, twice the weight that they should be, fluid in the lungs, which led to, as Mr. Grinander said, Dr. Perper's confidence beyond a medical certainty that the cause of Michelle's death was drowning. Now, if you consider defendant's own description of what he thinks happened to Michelle, that's also the most consistent with drowning, not a heart failure. She fell into the tub, head underwater. We don't accept that as true, as a true statement about how he found her, because every other witness says otherwise. But even if you accept his own description of finding Michelle in the tub, that's most consistent with drowning. Furthermore, inmate number, I've got to keep him straight. Inmate number 4, when he asked Martin about Michelle's death, Martin said, "The bitch drowned." Inmate number 1 describes a very lurid scene of Martin purposefully drowning his wife. Why would Martin tell them those things when he's got an autopsy report saying heart problems? It's because he drowned her, and he knows he drowned her. Mr. Spencer brought up lividity and that it was not seen by the paramedics, but you heard the paramedics testify they weren't looking for it. They're not rolling the body over checking for lividity. They're doing life-saving measures, and they roll the body over to clear the airway, as Martin should have done as a trained physician knowing CPR. Okay, all of this is to say, science plays a limited role in this case. It certainly informs it, but it doesn't decide it for us. Unfortunately, that weighty task falls to you. I say unfortunately because it is a weighty task. It'd be nice to have someone come in and say, here, it's solved for you. Here's your homicide. You know, we've packaged it all up nice for you. The fact that it's not packaged up neat and nicely like that, as Mr. Spencer would want, doesn't mean that this isn't a homicide, that this isn't a murder. It simply means that the science can't get us there, can't tell us that. Mr. Spencer asked you, talking about the inmates, whether whether bitch was an unusual word to use in prison. Probably not. Calls for you to speculate about that because we don't have any evidence about how often it's used. But probably not an uncommon word. What is the evidence about Martin's use of the word bitch about his wife? Inmate number 3 said he was really taken aback by that. You don't talk about the dead that way. Inmate number 4 testified, maybe we use that word, but in the context of using it to describe your deceased wife, man, you don't do that. Why would you talk about her like that? Talking about her like that shows the same type of contempt that is consistent in Martin's actions after Michelle's death. You've seen that already. Putting down her burial date as the date of his liberation, the date of his ability to marry Gypsy, that's callous, that's cold, that's not just odd or an idiosyncratic gesture by a guy who's a little weird. When you take all of that together and weave it all together, that speaks to a man who's killed his wife and knows he's gotten away with it so far, and has no regard for her whatsoever. Federal inmates' bias and prejudice. They all talked about they liked Doc. Doc helped them out. They have nothing against Doc. They left on friendly terms. There's no real bias or prejudice there. Motive. They all told you about the risks that they've taken coming out here. They've told you that none of them, not a single one, has gotten anything or has a guarantee for anything. A couple of them talked about the possibility of maybe getting something out of this. But again, who can blame them? These are men who are spending decades in prison for having a handful of crack and a gun. And if doing the right thing can also lead to benefit for them, who would hold that against them? That doesn't mean that they're lying. That doesn't mean that they're making anything up. And the fact that, motivations aside, the fact that they all talk about the same thing, they corroborate each other. And these are people who don't know each other, some of them in Texas, some of them here in Utah. They don't know the tox reports. They don't know the prescriptions that Dr. Thompson gave. They don't know the ME autopsy results. They don't know any of that. Their only insight into this case is through Martin MacNeill's statements. And there's a surprising consistency among them. Inmates in Texas, he referred to as a bitch, said she was glad she was gone. Inmate here in Utah, exactly the same thing. Talking about the drugs and drowning, multiple inmates doing that as well. They cross-reference each other, which supports their credibility. Back to motive, if you think about how all of us act every day, none of us acts with a single, solitary, pure motive. If I'm doing a good job at work, it's because I'm an honest employee. I want to do my best. I also want to get paid, get a raise, get a promotion, get a good reputation. Those aren't incompatible. The fact that I want a raise does not negate the fact that I also want to be a good, honest employee. So Mr. Poirier, the fact that he got a deal on his cases, which wasn't all that smoking hot of a deal anyway. He was expecting to get off on everything. He ended up pleading to yet another charge, doing his time. The fact that he got something out of coming forward and doing the right thing doesn't negate the fact that he's doing the right thing and that he's telling the truth. He sat there with no obligation whatsoever to be here other than our subpoena, and took his lumps, had his whole life laid out in front of the whole world, didn't deny anything, admitted his wrongdoings, and conceded that he's not been a model citizen in the past, but that he's here to do the right thing anyway. He's off probation. He's got no pending cases. We have no hold over him whatsoever. We haven't. If he didn't show up on whenever it was, Monday or Tuesday, if he didn't show up, there's nothing we could have done to make him come. He knew that he was going to be filleted like that in front of the whole world. He talked about his business risks. He knew he was going to lose business because everyone was going to see him. He did it anyway because he said it was the right thing to do. Alexis, what motives would she have to go to these lengths to pursue justice if it weren't warranted. 6.5 years of investigation, huge cost in resources and time and personal energy and emotional energy for her. Coming into court, pressing the most serious charge that you can against somebody, taking the stand. Who would go to those lengths simply because they're mad at their dad? That's not reasonable. What is reasonable is that she wants justice for her mother, and this is the way this is the way to get it. Finally, in order to believe that all of these witnesses are incorrect or even lying, you'd have to accept this underlying theory of conspiracy, that the inmates would have colluded to somehow get the same story, that the press is somehow involved, that the investigators are feeding information, that Alexis is making stuff up, as well as Rachel, as well as Vanessa, as well as Sabrina, as well as the neighbors, as well as the paramedics, as well as the police. The idea that all these people would come together to describe the story that you've heard in a way, in some sort of vindictive effort to convict Martin, that they would make things up, that they would, evolve their perceptions over time, that they would conveniently clarify their memories to add stuff in that looks incriminating. That's an absurd idea, that somehow all these people that you've seen, many of whom don't even know each other, would come together to create this story for you in a way that isn't really true. That doesn't hold water. I'm not going to go on and on about the witnesses. I think you can look at these supposed inconsistencies and discern for yourselves how important they are. One of the instructions about witness credibility talks about how important are the inconsistencies that have been pointed out. For example, the neighbors and the clothing. The first couple of days, we had a lot of questions about the clothing. What was she wearing? What wasn't she wearing? Turns out all of them were in part right and in part wrong. Fallibility of memory over 6.5 years is to be expected. In fact, if we were to believe that they were all, for example, Christy and Doug Daniels, sitting together and getting their stories straight to make sure that their neighbor Martin is convicted for whatever reason, why would one say dark top, the other say white top? The fact that they're both right, but they're not perfectly right, actually lends to their credibility. They're honest about their memories, which is what that instruction says as well. Honest people can remember things differently. Some people remembered the white shirt, some people remembered the dark shirt. Turns out, I don't know where they are right now, but it turns out they're all right. A lot was made in opening statement, and it was brought up again in closing about pink sweatpants. Fuzzy memories, 6.5 years going by. Turns out there was a pink towel thrown over the lower part of her body to cover her up. So all this talk about the witnesses, defense counsel spent a lot of time there. There are certain of defendants' own actions and statements, besides what the inmates tell you, that corroborate what we've been saying. 3 questions that really can't be answered outside of murder. First, why would the defendant push for that cosmetic surgery and then misrepresent to everyone after Michelle's death that he didn't want her to do it? Neighbors and, Dr. Welch told you. Michelle was hesitant. Martin was anxious for it. Alexis told you. Michelle and Martin had a disagreement, even an argument about why do we have to do it now? Why should we go forward now? And he's telling her, if you don't do it now, you're not going to get it. We've already paid Dr. Thompson. We've already reserved the anesthesiologist, blah, 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 blah. Got to do it, got to do it, got to do it. And then afterward, immediately afterward, the neighbors are in there watching him stage this phony grief. Why did you have this surgery? I told you not to do it. Oh. Why would he do that when he was the one pushing for it? And there are 2 separate witnesses who can tell you that. Medical staff at the American Fork Hospital. This damn surgery, why'd she do this? Why would he lie about that? Church members as well. Michelle wanted, colleagues at the USDC, Michelle wanted the surgery. I didn't want it. She was always wanting to be beautiful. That was her idea. When it's clear now to us with all of the evidence, that was Martin's idea. She was on board, but it was Martin's idea. Why would he imply afterward that it wasn't? Because that cosmetic surgery was the vehicle by which he could render her vulnerable enough and have a plausible explanation for why she'd have drugs in her system, why she'd be perhaps weaker or more prone to a sudden death. Second question, why would defendant lie about the pills? Why would he go to Dr. Thompson and ask for extra drugs, knowing as Michelle's primary care physician and her husband that she doesn't like taking drugs, she's sensitive to drugs? Why would he go and ask for more? And then afterward, upon finding her dead with other witnesses around, exclaim, why did she have to take all these medications? He knew full well she was down to 1 to 2 Percocets a day. Alexis told you that. Dr. Thompson had it in his notes. And Alexis testified that Martin was at that last post-operative visit the day before Michelle died. Martin was present. He would have heard all this discussion about the 1 to 2 Percocets. And yet, immediately after the death, before a tox report came out telling us all those drugs that were in there, he's already setting people up for the expectation. Why did you have to take all those meds? She wasn't doing it like she was supposed to. Furthermore, why destroy the pills later? Why have your son's girlfriend do it? Why the disappearance of Alexis's black logbook describing what was taken and when? The reason why is those can answer the question of what was Michelle taking, how much was in her system. You heard from the medical examiners and the toxicologists, it's difficult to talk about drug levels after death and go back and figure out what was going on before. You think they may have been helped if they had had a list of the drugs that somehow disappeared, a pill count for each drug to know maybe she took this much, maybe she wasn't taking any at all. All of that is an unknown now because of defendant's actions in destroying that. Defendant knew that she would test positive for those drugs in the toxicology report. That's why he's setting it up early on. He had that covered, though. As inmate 2 told you, they can't prove anything because all those drugs were prescribed. As inmate 1 said, defendant told me that it'd be hard to prove because she just had surgery. It looked like she just took a bath, took a bunch of drugs, and kind of nodded off. Very plausible explanation. Finally, the last question, why would he lie about the position of her body? Now, Mr. Spencer really tortured Ada's statement to come up with the idea that she was describing something consistent with what Martin said and inconsistent with what the neighbors said. Ada said that Michelle was in the tub, all the way in. Her feet were in. Martin's telling everybody that she's face down this way, with her legs and her feet sticking out. He's telling other people that she's draped over the tub like this, half in, half out. That's not consistent at all with what Ada said. She's all the way in the tub. Her legs and feet are in the tub. What Ada said is perfectly consistent with what Christy Daniels, Angie Aguilar, and Doug Daniels said that they saw. She was in the tub, slumped down, her head over here by the faucet. That position is very consistent with what inmate 1 said about drowning. It's very consistent with these 4 witnesses. The idea that she fell headfirst into the water or that she was slumped over the tub with part of her body out is inconsistent with everybody's statement except Martin's. So why would he lie about that? He's setting it up for an accident. He's setting it for a natural cause of death. He knows she drowned, and he knows he's got to figure out a plausible explanation for how that happened. So instead of describing it consistently, for example, when he talks to Dr. Fricke, he describes it in his version of events, which is completely inconsistent with all the other witnesses. Okay, with Lastly, let's talk about alibi. I don't know how is that going to warm up and get brighter, or is that
I think that's as bright as it gets.
okay? Could we lower some of the lights? Okay, defendant showed you his timeline, this is ours. In the morning, hopefully this, sorry. Okay, I think this thing out. In the morning, Martin's at work early, okay? Makes a call to Gypsy's cell phone. The day goes along, he's making runs home to get the kids to school. He's making calls from his phone, office phone. Show he's at his office from 9:11, 9:14, 9:17. 9:26, no, okay, let's step back for a minute real quick. 8 o'clock. Melissa Frost is told, look, your award ceremony is at 11:45, but you got to move it up. We got to do it based on Martin's or Dr. MacNeill's availability. So we're going to move it up. She protests, oh, no one's going to be there. Why does he have to receive it? Eventually she agrees. She moves it up. Or she agrees to move it up. So then she's told, be ready at any minute, and when Martin arrives, we'll do it. Okay? He's making calls from his phone. 9:26, he makes the last phone call. Show it to you so you don't think we're cherry picking here. Even though it's dark. Underneath this highlighted one here, you'll see 9:26. And that's Gypsy's number right there. Okay? And then you'll see the next call is at 11 o'clock. These are his office phone records. Okay? So 9:26, last call in the office. Coincidentally, right about 9:30, Melissa Frost receives a second call. Oh, never mind. Martin's not ready yet. He's not available right now. We're not going to do it. We'll let you know. We're not going to do it now, earlier like we thought. Okay? So, last call in the office, around the same time, we're not going to do the award ceremony now. Implication is, or the inference is, Martin's not available. Next call in the office, 11 o'clock. Just shortly before that, in an estimated time, Melissa Frost gets that third call. Martin's ready right now. Get ready. We're going to roll right now. Okay? So from that point on, he's got an alibi. He makes his phone call for about 6 minutes to Quest in his office. He goes to the safety fair. He's insistent to Mr. Laycock, where is it? I got to get the award. I got to be in the photo. He receives the award from, well, I don't know if Ms. Frost gave the award out or not, but he receives the award at the award ceremony. Ms. Frost says that's the only time she sees him there. Jim Vance says that's the only time he sees him there. Roma Henry, that's the only time I saw him there. Dave Laycock, that's the only time I saw him that morning. Okay? He receives that award, mills about, talks to people for a while, goes to pick up Ada from school, goes home, and all of the mess starts. Okay? There is absolutely no evidence of where Martin was or what he was doing in that space right there. When you want to talk about alibi, this is an extremely weak alibi. All the medical examiners agreed Michelle could have died any time during that period. All right. When you start out deliberating, when we started this case, we start from the presumption of innocence. Okay? Blank slate. We don't know anything. As the evidence builds, as you get more and more, as you piece it all together, Mr. Peed said this in his opening exam, Mr. Grunander repeated it. This case is a puzzle with many pieces. As you examine them all and piece them together, you'll start to see the case come together, as hopefully you've done as it's unfolded in front of you. That's where you start. As you go on, though, more and more of the case gets revealed. Now, why did I leave some of these puzzle pieces up here? I'm going to have you turn to instruction number, let's see if I can find it, number 17. This is the law about reasonable doubt. This is your definition of reasonable doubt. Mr. Spencer gave you his, which I'm not claiming is inaccurate, but the way he portrayed it to you made it seem like it was an awfully high burden, awfully difficult to reach. This is what your standard is in this instruction right here. Okay? You must find that the evidence proves this beyond a reasonable doubt. I'm going to have you go down to the middle of the paragraph. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. Now, I would submit to you that the evidence that we've shown you can't be complete. It's never complete in any case. No one ever knows everything that happened in any criminal case except the people involved. One of those people here is dead. Okay? The other, okay? So, we can never know everything. Okay. So why these pieces left? It's to merely acknowledge, look, we don't have every piece of the puzzle here. But in order to be firmly convinced, can you tell what that is? Hopefully you can. We've seen it before. Okay? You can tell what's gone on without every last single piece that you might want. That's the point. Proof beyond a reasonable doubt leaves you firmly convinced. You can see what happened in this bathroom on April 11th, 2007, without having every last little piece plugged in, okay, if you're firmly convinced. If you go on in that instruction, there are very few things in this world that we know with absolute certainty. You're not required to know with absolute certainty here, okay? And in criminal cases, the law does not require proof that overcomes every possible doubt. Okay? So we're not talking about speculative doubts. We're not talking about conjectures. We're not talking about some of the things that Mr. Spencer put in front of you. Maybe it was this. Maybe it was that. Could have been this. Those have to be based in reason that comes out of the evidence. So you take the evidence, you use your reason, you use rational principles, and you come to a conclusion. Okay? We're not talking about any old doubt. Well, it could have been this. There's, anybody can hypothesize any number of doubts that are strictly possible. Okay? This standard does not require that we disprove every single possible doubt. Only that you be firmly convinced of his guilt. Again, and that's restated in the next sentence. If, based on your consideration of this evidence, you're firmly convinced that the defendant is guilty, you must find him guilty. Okay? Now, some of these pieces are missing. This goes to count 2. I will learn this thing before the day's over. A lot of those pieces missing are due to defendant's own misconduct in this case. He lied about the surgery. Why did she want to do this? Why did she have to do this? I didn't want her to do this, when in reality he was the one pushing for it. He lied to Dr. Fricke, the medical examiner, about the position of her body. He also lied to paramedics and police in the same way. He destroyed the pill count. Okay, so Eileen and Damien sit down and help him do this count up of the pills. Gone. Black book. Gone. Pills themselves. Gone. Okay, a lot of the missing pieces of this puzzle come from defendant's actions, and that's called obstruction of justice, when you destroy evidence, when you lie to investigators, when you prevent an investigation from even getting started, or you delay it, or you make it more difficult to find out the truth of the matter because of your wrong actions. That's count 2. That's obstruction of justice. So as we go back to this, I want to end by saying that there is proof beyond a reasonable doubt here. When you bring all this stuff together, there's no reasonable explanation contemplating Gypsy, contemplating the lies that Martin's told, contemplating the inconsistencies in his stories about the bathtub of Michelle's body. Why the spikes in medications? Why did Martin ask for more medications? Why did he move her in right off the bat? Why is he going through all this subterfuge about what's really happening? Why is Michelle dead a few days after she starts confronting him about his relationship with Gypsy? And then why is Gypsy so suddenly moved in? Why is Gypsy talking about a sudden uptick in the seriousness of their relationship at right around exactly the same time that he's looking for a plastic surgeon? Why is he looking for a home nearby? Why is he paying for everything for her? This isn't a casual relationship that, an alternative lifestyle. This is swapping out Michelle for Gypsy on Martin's terms. I'm not going to pay alimony. I'm not going to give up the house. I'm not going to lose, be paying child support. I'm not going to go through the humiliation of being discovered as an adulterer and a religious hypocrite and lose all my friends, lose my status at work, whatever might happen. I'm not doing that. I'm going to switch out Michelle for Gypsy on my terms. And that means Michelle's got to die, because otherwise there's no way to do it. That, there's murder that happens on the streets, and then there's murder that happens within someone's own home at the hands of someone that they trust. This has been a long time coming. A lot of investigation, a lot of work, and now it's up to you. And we encourage you to find Martin guilty on both counts. Thanks.
Thank Could I ask one of you to move this so I can see the jury here? Ladies and gentlemen, I've previously instructed you that the closing arguments of counsel are not evidence. Admittedly, summarizing the evidence presented over a period of 4 weeks is a very difficult task for counsel. And sometimes misstatements can be made. In rebuttal, the prosecutor stated that murder cases are decided all the time without a medical examiner coming into court and giving an opinion of homicide. There is no evidence before you as to whether or how often this occurs in murder cases, and I'm instructing you to disregard that statement. I will now review with you the verdict form. A single verdict form will be sent into deliberations with you. It provides, in the 4th District Court of Utah County, State of Utah versus Martin Joseph MacNeill. We, the jury, having reviewed the evidence and testimony in this case, find the defendant, as to count 1, murder, guilty or not guilty, as to count 2, obstruction of justice, guilty or not guilty, dated this blank day of blank 2013, with a line for the jury foreperson to sign it. Ladies and gentlemen, when trials are lengthy like this one, it is not uncommon for circumstances to arise that require a juror to be released. For this reason, the rules of criminal procedure permit the parties to request that alternate jurors be appointed. Thus, the appointment of alternate jurors is a cautionary measure to ensure that a full jury exists at the beginning of the case as well as at the end and can deliberate on the case, notwithstanding unforeseen circumstances. 3 of you were selected as alternate jurors in this case. I was not at liberty to disclose that fact to you until now, so that all jurors will pay equal attention to the evidence presented. At this stage of the proceeding, the case will be delivered to the jury for deliberation, and it's my obligation to release alternate jurors from their assignment. The alternate jurors, each of you, I believe, can remember your juror number. Is that right? The bailiff reminded you of your juror number. And if you'll stand as your juror number is read, alternate juror number 87, alternate juror 88, and alternate juror 93 have been serving as alternate jurors in the case. On behalf of the court and the parties, I thank you for your service as alternate jurors. While you will not deliberate with your fellow jurors, your service has been essential to the resolution of a very lengthy criminal trial. You'll now be released from that obligation. The bailiff will take you out. All rise for the departure of the alternates. Thank you. Please be seated. I will direct that the clerk gather all exhibits so that they can be provided to the jury during the course of deliberations. Each of you have received a copy of the jury instructions. You may use them as you deliberate. Take them into the jury room. You're also free to take your notes into the jury room with you. At each break in the trial, I have instructed you not to form or express an opinion and not to discuss the matter amongst yourselves. It is now your duty to do both of those things. and to deliberate with a view to reaching a verdict in the case. Therefore, the clerk will now swear the bailiff, who will then escort the jury to the jury room. There you will receive all exhibits in this case, and you can begin your deliberations.
You do solemnly swear that you will keep this jury together in some quiet and convenient place until they agree upon a verdict or have been discharged by the court, that you will not suffer any communication to be made to them or make any yourself, except to ask them if they have agreed upon a verdict, that you will not, before the verdict is rendered, communicate to any person the state of their deliberations or the verdict agreed upon, and that you will return them into court when they have agreed or so ordered by the court, so help you God.
Yes.
Thank you. All rise. Thank you. Please be seated. Counsel, periodically the jury may have questions. I would prefer to resolve those here in court on the record rather than to do it by telephone. But I know that that will require you to come back. How would you like to proceed?
However Your Honor wishes.
We're fine with that, Your Honor. I live locally here, and counsel can.
Okay. You're free to leave the building. If you can be within 10 to 15 minutes away, that would be very helpful. If you'll leave a contact number with the clerk so that I can call you in the event that the jury has questions. This concludes a very lengthy criminal trial in the state of Utah. I'd like to take this opportunity to note for the record the exceptional legal work performed by counsel in this case. The case has presented difficult legal and evidentiary questions. Advocacy from both the prosecution team and the defense team has been thoughtful and persuasive. The presentation of testimony and evidence has proceeded efficiently and persuasively. To those interested parties, you have been represented by skilled legal advocates, and zealously the many years of study of the law and their practice has been brought to bear in a way that has been exceptional during the course of this trial. I note further for the record that counsel have been models of professionalism and civility, and express to each of you my gratitude for your work. Court's in recess.
I have one question.
Yes,
Go back on the record.
I'll be back on. Please be seated.
In the event when the jury returns a verdict, we have a number of family members of Michelle, and I'm wondering how much time the court would give us to notify them before the verdict is actually announced.
How much time do you need?
The request is actually about an hour, and I wonder if that might accommodate some of the media as well. But I throw that out there to the court.
Is anyone going an hour away? Or can they remain within half an hour?
I know Ms. Summers has very young children at home. She lives in the South Jordan area.
My only concern is jurors have been at this for a long time, and once they have ultimately reached a verdict, my sense is that they would have a strong desire to have that verdict read in a timely fashion and be released from their obligation. Let's plan on a 45-minute delay, I think is fair. If there are complications with that, I recognize there are interested parties here, and you just need to let me know.
Thank you, Your Honor.
Court's in recess.